You're listening to the Secure AF podcast.
Welcome to the Secure AF podcast. We're really excited to have Tom here today. We're going to be talking about some legal stuff, some PII stuff, and some compliance things. It's really important for us in cybersecurity to know about these things and to understand them. So I've invited my friend here to come and talk about this stuff. So I'm Jonathan Kimmitt. I'm CISO of Alias Cybersecurity. Tom, who are you?
My name is Tom Vincent. I know you know that. Now, all these people do. I'm a partner with the law firm of Pearson Ferdinand. I have been practicing in cybersecurity, data privacy law, and associated areas in private practice for over 10 years and in an internal role for longer than that. I won't say how long because then I just get depressed. But we are going to be talking about some interesting things today. As you said, the legal side of the equation is often just as important as the technical side of the equation, but more so, as you and I have talked about over, the last decade, often it's not just security that needs focus, it's the privacy side as well, which isn't always looked at the same time or the same way. Before we do go any further, though, I need to stress that this podcast is for informational and educational purposes only and does not constitute legal advice. The views expressed herein are my own and the individual speaking and do not necessarily reflect the views of Pearson Ferdinand LLP or any other affiliated entity. No attorney-client relationship is created by viewing or listening to this podcast. Information may not be complete, up-to-date, or applicable to your specific situation, and you should consult with a qualified attorney for advice relevant to your circumstances. This podcast and any associated materials may be considered attorney advertising, under the rules of certain jurisdictions. Prior results do not guarantee a similar outcome. This is the sort of thing I did when I was in financial services, and it just follows me everywhere.
Yep.
But with that, let's talk about, I've given you a little bit of my work history, but let's go into yours and then I can add to it because I think it will be helpful as we get into the specifics to see, one, the perspectives that we're coming from, but also just why it is that we think we know what we're talking about.
Yeah. Well, and that's actually really important because, when you and I got together, I was a young CISO, It was a long time ago. I have a lot more gray hair nowadays. But that was the thing, back then I was learning to be a CISO and working at a university, which has some interesting aspects to it in terms of how you have to deal with cybersecurity and privacy and all the different things you have to do. And you and I got together for a particular compliance, GLBA. That was one of the first things that we worked on. And I'll tell you this, working with you and learning those pieces that you came with to the conversation about legally what you had to do, why we had to do it, why it was important for the organization was incredibly important for my development as a CISO. And so when you and I started talking about getting together for this podcast, that was one of the things I was really excited about because that's what really helped me grow in my field, in my art. And when I talk about CISO as being an art form, making decisions and doing things for the organization, that's really where that started to develop. And throughout my entire CISO career, privacy has been a huge piece. Now, right in the middle of that, we had GDPR come out, and that really changed the landscape for PII, but more importantly for CISOs, having to manage the systems that PII resided on or the processes that PII was transferred on. Of course, PII is personally identifiable information. But when we're talking about that, the CISO is what protected that data and all the different processes around it. So my thought was, and I still believe this today, privacy told you what kind of information you could have, and the security protected that information. So it was very complementary.
Mm-hmm. No, go ahead.
No, go ahead.
Well, I was just going to say, no, I appreciate that, and likewise, one of the things, especially being a cybersecurity lawyer, which not so much now, but when I first started doing that, I started our practice group formally in 2015 at my prior law firm and had been doing this unofficially, I guess if you want to call it that, before then. But people would ask, so what does that mean? What is taking a technical term and slapping it in front of a lawyer? What does that person do?
Right.
And I think for lawyers in this space, it's very helpful and almost essential, really, to have that understanding from the CISO perspective, because often when we are looking at everything from either a company policy that we may be working on to an agreement with a vendor that sets out particular requirements for the vendor's behavior, and also in some instances definitions and qualifiers for what constitutes a breach of that agreement.
Right.
But also when we are doing more non-technical things like training employees, or even just trying to respond to a client's question, being able to understand, okay, this is really what the effect is.
Right.
It's not so much that I can say, well, if ABC vendor breaches an agreement, then there's going to be this much in damages owed. I have to understand, well, how could they breach that? And not just, well, if some information gets out that shouldn't, but how could that information get out?
Right.
And what is it that I need to be aware of for my client, not just to say, if this happens, then they breach the agreement, but what might you need to do to keep that from happening?
Right.
And similarly, as we've talked about before with respect to privacy and security, you mentioned that interplay somewhat. I know from a company side, we often think of privacy as how the information that a company accumulates is shared and not shared. Obviously there is some sharing that's needed, but for example, if you are wanting to use a service from a company and they have a third party that does that, you're going to have to share your information with that third party, or at least the company is. But more than that, even just at a more visceral level, when we talk to individuals, and I have heard this from my students at the University of Tulsa, where I'm an adjunct professor of cybersecurity law and policy, as well as individuals I've worked with respect to data breaches, is if you ask them the difference between privacy and security, they really don't see a distinction.
Yeah.
They really gravitate towards, well, if information is secure, then that means my information is private and my privacy is maintained. And so for many people, privacy is just the net result of successful and effective security.
Yeah. I mean, I guess I see it a little differently on the CISO side, because I've always looked at security and privacy as a Venn diagram, and it's mostly covered, but there's the sliver around, the size. I mean, you can take something that has all of the security controls in it as appropriate, and someone makes a bad decision and that data is now breached, or there's at least an incident. I don't like using the word breach. He can use the word breach. He's a lawyer. But, from my point of view, there's been an incident. There's been unauthorized access to data. And I'm going to investigate that to determine, okay, was it a failure of the controls? Was it a failure of our processes? What was it that caused that unauthorized access to data? But there are some cases that is absolutely not a controls issue, not a process issue. It's a decision issue. And I think that's really important to understand, because that is where I think those two pieces are separated a little bit, where you can have full security and still have a violation of privacy.
Sure. And which is a good sort of segue into the reason we're doing this podcast, and the series that will be following this is because privacy and security do overlap sometimes. But are also seen in some instances to be the same thing. It's important to understand when they are and when they're not. And so what we are intending to do today is just to give you all an idea of what this discussion looks like by really starting at the beginning, the initial discussions that both Jonathan and I have with many clients, often in the circumstances that we would prefer not to have with clients, which is when there's been a data breach, and we'll get into that there's a reason we're hesitant with that term, which we'll get to here in just a bit. But whenever clients experience an issue with their information, often the comments that we get from them, I know speaking for myself, and I know Jonathan has shared some of these, and please do share some of yours as well, are things like, I didn't think I had any information to worry about.
Yeah.
I didn't know I had any privacy obligations.
Right.
I thought antivirus software was enough.
Right.
And in all of those instances, we've seen two key misunderstandings. One is, what is this information called PII or whatever it's called in any number of statutes and regulations?
Yep.
And also, what is it that having that information requires me to do?
Yes.
Because to your point, Jonathan, you can have security features that are industry standard, but if there are certain things that can be done with that information, or if there are ways that information can be misused, I'll give you an example. A client some years ago came to me with a question about a potential data breach. What had happened was one of their receptionists, this was a healthcare clinic, one of their receptionists went to lunch, came back, and her husband had sent her flowers. And she took a picture of this, put it online, and 10 minutes later realized that the flowers that she'd taken a picture of made it into her Facebook account, along with the patient list that the flowers were sitting on.
Yeah.
And again, notwithstanding any other issues right now other than this issue of security versus privacy.
Yep.
That information was something she was entitled to have, and she had it in such a way that was permitted by her employer.
Mm-hmm.
It's just her choice to do something with it.
Sure.
As you said, decision-making played a role in it, and decision-making isn't something that security can necessarily control.
Right. And that's something I really have to work on with my clients is a 50-cent decision can bypass a $50,000 security control every single time. And it's those decisions that we really need to be careful on. And I'll even go one step further. When we talk about security and privacy, and we talk about security as protecting that data, well, then you have this idea of privacy is telling you what kind of data you can and can't have. You can absolutely have data that you have completely secured, but if you're not allowed to have it, that's in violation of a data subject or an individual's privacy. That I can have all the security controls around it. It can be completely encrypted. It could be everything I can do to it to make it secure, but it's still a violation of privacy, just the fact that you have it. So that's really something that when I go and I talk to organizations and I ask them, okay, well, what, and I'll use a variety of different terms, PII, PHI, NPI, all the different acronyms. But when I say, why do you have that? And if they don't have a good reason for it, it's like, okay, the first thing we have to figure out is, can you have that? Because if you don't need it, then I don't need to secure it. And that makes my job easier.
Right. So I want to circle back and then get to the point that you're making. Because I think you've raised one of the fundamental questions following the comments that I just shared, which is, okay, what is it that someone in that position should have known?
Right.
And so that's one of the things that we're hoping to communicate to the audience here is, what is it that you as the company, entity, business need to know about your own information practices?
Yes.
And if you are a customer of such a company or a vendor, even if let's say you're providing insurance coverage, let's say that you are providing third-party services to that company, these are some things that you should probably be asking them if any of your information is going to be shared with them.
Right.
So let's get to the first point you made, Jonathan, which is this idea of PII and all of the different terminology of that. Why don't you just give a general description of what PII is and how someone might have that information?
Yeah. So the way I talk about it, and I'm sure it's going to be different from the way you talk about it, but the way I talk about PII, personally identifiable information, is a set of two or more fields that you can use to identify an individual. So a name, while a name can be unique to an individual, it's really hard to determine if that really is the right person. There's a handful of Jonathan Kimmitts in the world. But if you do my name along with another identifier, such as my address, now you're getting down to an individual, a person. If you do my name and my date of birth, there's probably a low chance that there are two Jonathan Kimmitts that were born on, I'm not going to tell you my birthday, but on the same day. So when I talk about specifically PII or identifiable information of an individual, I always talk about you got to have two pieces of information. If you have just one piece, you just have an Excel spreadsheet of a whole bunch of birthdays. Those are just dates. You've got to have something else. Now, I try to get it across to people is it doesn't have to be the name. You can do a social security number and a date of birth. You can do a address and a social security number. There's a whole variety of things. If you put together, you can go, oh, that's that person. So I am looking for when I'm working on a system or a process or an individual, I'm looking for those data elements. I'm looking for that data element that I can use to identify people. Mm-hmm. And I'll tell you, I have found stuff in trash cans, shredding cans. I'll walk up and I'll pull it out and it's like, oh, here's a whole bunch of names and addresses and ID numbers and this. But it was shredding, but it wasn't shredded yet. Until it's shredded, until it's secured, then that is PII, or depending on which. And here's the thing, I will say this. There's a lot of different ways we call this data. It's PII. There's non-public information, NPI. There's private health information. There's data subject information if we're looking at the EU or any of those. So I am going to generalize it and just say PII, but what I'm meaning is any sort of identifying information, regardless of the compliance we're talking about, I'm going to use PII because that's what gets in my head. And I also call them data subjects and controllers and processors because that's how I deal with my daily stuff, is those are the words that I use. Mm-hmm. So how would you describe PII?
Well, the way I've described it simply for people is anything that can identify an individual. And this is where, again, I want to draw a distinction in what, we've talked about compliance requirements and things like that. A lot of what Jonathan and I are going to be talking about goes beyond some of the basic compliance requirements, in part because both of us have seen instances where just doing the bare minimum doesn't work.
Yes.
It doesn't work either from the standpoint of the effectiveness of the control. It doesn't work from the standpoint of the sentiment of the customer whose information is exposed. And it also may not work to the satisfaction of a particular regulatory agency that is supervising the entity that is collecting and utilizing that information.
Right.
But I think to your point, Jonathan, and to just simplify it down, I think any piece of information that can identify an individual. And again, because going back to that individual perception of privacy versus security, you may just have someone's name, but if you say, well, your name got out, my name's out there, but let's say your name got out in a breach of a cancer treatment center, then already there's a lot of other information with your name that is attributed to it.
Right.
And so with respect to PII, that is one way that PII can be collected is through association.
Sure.
But even more fundamentally, and first of all, as we were talking about before, not that we're not going to go into a whole lot of detail on the owner's PII in the event of a sole proprietor or anything like that.
Right.
There are reasons, obviously, to protect your own PII.
Yep.
And we will, in one of our episodes, go through what are some of the personal steps that you can take in the event that your information is compromised. What we're talking about here really is information that you as a business owner may collect from other people. One way that you may do that is through web traffic.
Yep.
Many of the larger companies that we work with, and many of the small ones also, from an efficiency standpoint, use different tracking technologies on their website that collect things like IP address, geolocation, things like that. All of those in different statutes and regulations may be considered PII. Similarly, if you are asking people to provide their contact information, you're actively soliciting PII.
Yep.
You know, and also if you are if you are using that information to then develop a profile of a customer, in some states that can be considered PII.
Yeah.
Even if all of that information that you use to develop that customer profile is public.
Yeah, and we had to be careful on the public thing, because one of the things I run into a lot, especially when I'm dealing with contracts, is they will put in there that they won't be responsible for public information, and, in case of an incident or a situation. But I always redline that contract, and I always put legal public information, because I've had people say, "Oh, no, that was in this data breach. That's public. Therefore, we didn't breach it." It's like, no. That was breached data. That was illegal data. You can't use that.
Well, to that point, actually, one thing I wanted to footnote from an earlier comment you made, just in case anyone is curious, you mentioned items in a shredder that hadn't been in a shred bin that hadn't been shredded yet.
Right.
Point one, always lock shred bins that have personal information in them.
Yes.
Point two,
it wasn't.
With respect to that, especially if you are contracting, not even with that, but let's say you're contracting with a data broker who performs credit checks, and they probably have any personal information that you are already wanting to put in there. What I typically do for my clients, and we'll go over this in detail in a future episode about specific contractual provisions that can help, is I always put a carve out right after that exclusion from the definition of confidential information that says essentially any personal information or PII that my client provides you always remains confidential.
Yes.
Because if there's been a breach, or if there has been the party that you're contracting with already has that information, then fine. You may not consider what you have public, or confidential, but if it comes from my client, it stays confidential.
Yes, and that's gonna. I really want to explore that later when we talk about that controller processor relationship, or controller processor and sub processor relationship, because as third party management or third party vendor management becomes more important, especially when they get more data out, that's something we have to deal with. I've had third party vendors who they wrote in the contract that any data that was provided to them, they get to have forever. No, I'm not going to do that. So, but that's something that we will talk about more in later episodes, because that's incredibly important. And that's one of the things that, when I'm working with someone and we're dealing with contracts or vendor policies or vendor agreements, that's a key piece. You have access to data. The customer is giving you data for some reason, or you're collecting it. You have to protect that data. You are responsible and liable in a lot of cases for what happens to that data.
Yeah.
And that's why we're talking about this.
Well, and that's a nice segue to the second point, which we often hear, which is, I didn't know I had any privacy obligations. To your point about you have these obligations. The way that when I've taught my classes this, and to other professional audiences, I use the term expectation. We don't provide information. People don't provide information to us without some expectation of how it's going to be used.
Right.
My kid has some artist pages on different music streaming sites, and I give them my information not just with the expectation that I'll be able to hear her music, but also that they will protect my information in the way that they have provided me the details of how they will protect it.
Right.
And that's part of that interaction. So with respect to the privacy obligations, do you want to talk about some of those? And then we can go through how some of those specifics may interplay with some security obligations as well.
Yes, actually, I mean, when we talk about the obligations for privacy, specifically data, the first thing I always talk about is, I'll put it simply, has anyone ever died because of a data breach? And this is a question I ask at conferences and my presentations. And, and I always ask the audience, what do they think? And they always hem and haw. And almost every audience will come up with the ransomware situation in Germany where someone died because they got redirected to another hospital.
Mm-hmm.
And that's not what I'm talking about. My question is about, has anyone ever died because their personally identifiable information was released to the public inappropriately? And the answer is yes. And we'll get into that story in a different topic or a different podcast. But people have died. So now, thinking from that perspective, if I am the controller, so I am asking someone to give me some information, whatever that information is, if it is identifiable to them, then I do have an obligation to protect it. Now, this could be because of consumer protection laws. This could be privacy laws. This could be privacy regulations out of the EU. It could be state laws. It could be specific industry laws such as education or healthcare or whatever. I mean, there's a lot of different laws that really come into play on the obligations of you protecting that data. But I will say this, and this may not be as popular. I think, because I believe privacy is a human right, and I believe that above all else, our job, both in the cybersecurity side, and I think on the legal side, is to protect people. That's our job. That's what we do. We protect people, and that includes protecting their information that could be used to cause them harm. So while I think there's a significant amount of legal obligations that we have, either compliances or laws or whatever, I think there's just a fundamental obligation that if we're asking for information that could lead to harm for an individual, it's our job to protect it. Now, that's a lot of organizations will go, well, I don't really have the ability or the resources to do that sort of protection. Kind of what I say at that point is that's the cost of doing business. You should protect that data.
And to get to I want to pivot back a little bit on the different privacy obligations that you were talking about in general, which is essentially depending on whether it's at the state level, federal level, international level. Mm-hmm. Generally, the privacy obligations are only collect what you need, keep confidential what you get, and make sure that you take appropriate steps to secure it.
Yep.
And that's why I wanted to pivot to security here as well, because I have this discussion with clients all the time when they are looking at structuring their internal functions, privacy and security. In some smaller organizations, sometimes that role is satisfied by one person.
Yeah.
But as an organization matures, I think it's important to understand that as you said before, where those overlap and where they don't, because there is the privacy representations that people make, and I want to get to the sort of pivoting back to the expectations, how those expectations are established. Those different expectations are premised upon generally some understanding of how that information is secured. For example, it is par for the course these days, if you have a website, to have a privacy policy.
Sure.
It's something that different regulatory agencies, state and federal, look for.
Right.
And that privacy policy essentially says, here's how we collect your information, at least through our website. Now, some companies incorporate the subtotal of their privacy practices in their website privacy policy. Some limit that to a website, just the website, which either way, as long as you're addressing all of those issues somewhere, it need not all be on the website. But that is where someone typically should go first to see, okay, if I'm going to interact with this site, what is it that they're going to do?
Yeah.
And that will go into detail regarding the information that is collected, how it's collected. We talked before about website automatic collection and different tracking technologies. And it will also provide the website visitor / customer with information about not only how to find out what information is there typically, but also how to change that information or how to delete it.
Right.
And this is part of what you said earlier, Jonathan, regarding are you collecting the information that you need to collect?
Yep.
Because that is where I can tell you in my experience, and I know yours as well from conversations that we've had, a number of problems could have been avoided if information was not either collected excessively or shared excessively.
Right.
And by shared excessively, what I'm referring to is typically in vendor agreements, and I see this especially with smaller companies and even nonprofits who have agreements with different companies, with different vendors, who are able to obtain some sort of discounted rate because they are sharing this information that they may not see the value in it.
Right.
But what that does, certainly what it can do, is open the door to an incident later on or a breach if that information gets out. And I do want to take about 30 seconds here to talk about that term breach. We've hemmed and hawed around it, and we've talked about it and batted it around in this conversation. But the reason that both of us sort of laugh about it and we always say it's not a breach until legal says it is because the term breach is a defined term in many privacy and security statutes, regulations, rules, handbooks, and other guidance documents from state and federal governments and regulatory agencies. What breach means is that whatever threshold has been set to indicate that an individual's information has been compromised substantively enough that they need to be told about it, that threshold has been crossed. And that not only sets in place different notification obligations, but also timing obligations.
Yes.
And so when we talk about a breach, is certainly today, but going forward, when we talk about the difference between a breach and an incident, it's very important to understand that distinction. And particularly if nothing else, if you are having conversations about an incident with respect to your information security practices and something happens, please don't refer to it as a breach unless counsel or someone who has the authority to make those determinations weighs in and says, yes, this is a breach.
And I will say this, from a cybersecurity side, incident response, cybersecurity, investigative, I am very, very careful on the words that I use. And when I'm working with my clients or working with the people I'm doing jobs for, I make sure they understand those pieces. Now, I will tell you this, I'll be one of the very first people to say, get general counsel involved. If you don't have general counsel, let's go get external counsel, because I am not a lawyer. I know what I know. I am comfortable with what I know, but I also know that I don't know a lot of those pieces. And that's where you've always been a resource for me, whether it was, at the University of Tulsa when you were my external counsel, or if we were working together on a client issue, where we had the same clients.
Mm-hmm.
Those situations, my job is to do the incident response, to do the technical pieces, to do the things that a CISO does. And I'm always very careful of saying, okay, we need to go get help. We need to get someone to help us understand this, whether it be a breach coach or counsel or external counsel. And I think that that's really important, because that really sets the tone for me as a CISO when I'm working with a client, say, okay, here's what I do, but I need help doing these other things because they work together. And I can't do everything in my job without assistance from counsel. I provide information to them. They make some decisions. They tell me what I need to do in next steps. That's why when I do my incident response or incident command structure, counsel is right next to the incident commander because I need that person there telling me, okay, here's what we have. What do I need to do to meet these obligations, or what are next steps, or whatever? So I think that that's really, really important to understand. That's what I want the people in the audience to understand, is the reason why we're putting this podcast together is because of that. I need to know the security side and a lot of privacy side. But there are things that I don't know, and that's where you come in. That's where I rely on you to tell me, okay, this is what you're going to have to do next, and this is how you do this.
And thank you for that. And similarly, I would say that's why I think it's important for counsel to be familiar with and be able to speak to the issues that are relevant to a CISO and understand what those issues are, because often the legal determinations that we make, I'm just going to jump into the breach portion here.
Yep.
What if something goes wrong? Then oftentimes it is those technical elements that make those determinations and define those particular circumstances. So, we ask the question, what if something goes wrong? Well, often one of the first things we look at is what is the kind of information at issue?
Yep.
What happened to it? Did somebody see it, break it, or take it?
Yes.
Those are really the three questions. Dependent, because we also talk about, it's called the CIA triad.
Yeah.
Confidentiality, integrity, and availability. And particularly with respect to health information that's protected by HIPAA, that availability is very important. There are a number of relatively recent interpretations from Department of Health and Human Services that indicate that even if information hasn't necessarily been accessed, if the availability has been compromised, let's say it's been encrypted, that may constitute a breach unless certain circumstances are met.
Yep.
And so, again, we look at those factors, but then we get into, okay, from getting into those technical details in the context of the legal determination that has to be made.
Yeah. One
One of those, for example, under Oklahoma law, one of the conditions for a breach requiring notification to an affected individual has there been harm, or is there a substantial risk of harm? And that's often where I will lean on Jonathan, and we'll have long discussions about, okay, so what is the substantial risk of harm that something could happen here?
Yeah.
Do we know, even beyond that, do we know what information got out?
Right.
And how is that determined? And so anyway, I'll turn over. There's something else I was going to say, but I want your thoughts on that.
Well, and I think that determination is really important, because in some cases you've got to be able to prove something. And here's a perfect example. This was many years ago now. We had a situation, you were involved in it, and it was a broken website, effectively. So it had a directory traversal weakness in it. And we had to look at, okay, was data accessed inappropriately? And if it had been accessed inappropriately, well, then we have obligations. And again, I rely on that with Tom or with counsel. But the question comes up of, okay, it was the security control was weak on it. How do you know they accessed it? And now my question is always, well, how do you know they didn't? So, if you have 100,000 records behind this website, and I can't prove that something was or was not accessed, that's very problematic because I don't know what was accessed and what wasn't. But what I can say from a CISO perspective is it could have been accessed. Now, when we have a situation, let's say you had a malicious actor who got root access on a server.
Mm-hmm.
To me, once they have root access, they have access to everything on that server, depending on encryption and all kinds of different things, but generally they have access to it. And there's a lot of times I can't tell you what records that person accessed and what they didn't access. So there's a determination. Do you assume that everything was accessed and copied off or whatever, or do you assume nothing was accessed? And I've got into it with breach coaches before where I will tell the client this attacker had full admin or root access to this host, and there was X amount of records on this.
Mm-hmm.
I, as a CISO, can't prove anything. I can't prove they accessed it. I can't prove they didn't access it. But I always give them a warning that they had access, and I can't prove it otherwise. If this data shows up on the darknet in 3 weeks, then we know that everything was accessed. So I'm always hedging my bets there. Mm-hmm. But I've had other situations where someone says, no, you can't prove they took it. And that becomes problematic from a CISO perspective because I can't prove it. I cannot prove that someone took it or didn't take it. Now, there was that situation I alluded to earlier that I was actually able to prove in the logs who had accessed everything. Mm-hmm. And it was agents of the organization. We were able to prove, okay, here's where I accessed it when I tested it. Here's where this person accessed it when they tested it. And this is where the original access happened, and we know who did it, and they turned it in and whatever. So that turned out pretty well in that situation. But it gets really hard, especially when organizations don't have their logs. They don't have any sort of file management. It's really hard to tell one way or another. Now, let me ask you something on that. Mm-hmm. From a compliance perspective, what do you think a regulator, an auditor, or whoever it might be, would say? Would they lean on if someone has full admin rights or full root access to every file on a server, but we can't prove that they either saw or read those files or didn't? Which way do you think that regulator might lean?
I've seen it go both ways, often depending upon the type of information at issue and the surrounding circumstances.
Yeah.
If it was something where there was root access for a very short period of time, and the information was such that it was, excuse me, that it was PII, but not terribly sensitive.
Right.
Names, birthdays, things like that. Often, I shouldn't say often, but I've had some regulators I've spoken to have said, look, this isn't something that would trigger breach notification. It may be, and really what they're looking at, I think, is even if they did look at it, there wouldn't have been any affirmative notification requirements.
Yep. There's
a very little harm that they could have done with it. But that's why, again, and this is the just to echo the point that you made, is that's why you need someone in there to look at this and go, okay, here are the different levels of sensitivity. Especially if it's a situation, I've worked on breaches before where we've had international information with multiple nation states implicated as the host countries of individuals who lived in those, who were residents of those countries. And there, you're not so much dealing with, do you have to notify the individual? It's, do you have to notify that country?
Yes.
The government. And so that determination can be very important. And again, this just goes back to, and I'm going to time machine this back to like before the breach happened and just say, this is why it's so important. And not to give short shrift to this at all. This is one of the other sessions that we'll be doing, which is, the now that I know that, what do I do? Portion of the program, which is, now that I know this has happened, what is it that I should have done? Well, one of those, as you probably guessed from everything we've talked about, is know what you have.
Yeah.
And know where it goes. I joke with my audiences that my house is 108 years old, and sometimes it rains in the living room. But I know that it rains in the living room, so I can plan for that. And so, just like with with your information. If you know how it's coming in, if you know where it's leaking out and it's being collected somewhere, and you know where it's supposed to be leaving your organization, that's a start.
Yeah.
But part of this whole enterprise that we're talking about is to get people in the audience who may be at the I didn't know I had to do all this stuff to here's all the stuff that I've done.
Yeah.
And and it's got me in a much better position.
Right. Well, and that's the thing, when you and I were talking about this originally, knowing the things that we deal with on a daily basis with our clients, with my clients for me and your clients for you, and the things we tell them after the fact is like, well, you really need to do this, this, and this. And even when we go into organizations and they haven't had an incident, but we say, hey, you need to do this, this, and this. And they're like, why do I have to do that? And then we talk to them and we explain it to them. They're like, oh, okay. Yeah, that is really kind of scary. So, but we're running close on time here. And there's one other little thing that I kind of want to bring across, or I wanted to bring up before we end this podcast is I had a good conversation with a mutual friend. And this was years ago when she first came to the University of Tulsa.
Mm-hmm.
And the conversation was this. She didn't get angry with me. I don't want anybody to take that away, but she and I had a really good conversation about what my role was and what her role was. And I told her very specifically that as a CISO, my role is to enforce those rules and those regulations and the different pieces. And she kind of she didn't get angry, but she didn't quite understand that. And I said, well, here, I come from law enforcement. I was in Border Patrol many, many years ago. And you don't want a Border Patrol agent trying to interpret a law. They are there to enforce what they're doing at that time. The same way if you have a police officer who stops you on the street, they're not there to interpret the law. They're there to enforce the law. And I kind of look at the role of the CISO. My job is to enforce the rules, the compliance requirements, the regulations, whatever it may be. And I rely on my counsel to interpret those for me. I'll take them the list of compliances that we have, whether it be, let's say, FERPA or HIPAA or whatever, and I will ask questions because I need to know what I need to do on my side. Mm-hmm. And I think that relationship is really, really important. And I think it was the first time she had ever thought of it like that, to where she was thinking of it from her own perspective of, well, I need you to think like this. And it's not that I didn't think like that. It was that that's not how I work as a CISO. My job is to enforce what I have. So I think that that's really important for us to talk about, because in a lot of cases it is, I want you to help me, interpret something and tell me what I need to do. And then on the flip side, I'm going to come back to you and say, okay, this is possible. This isn't. Here's the requirements. Here's the things that we need to do from our resources. But I think that relationship is really important. I think that's why CISOs and legal need to have that partnership.
Sure. And I will say that's one of the advantages that Jonathan and I have in the time that we've worked together, and the fact that both of us spent a significant amount of time inside organizations trying to take what outside counsel gave us and make it work.
Right.
Is understanding that that in healthy relationships between CISO and counsel, between legal and technology.
Yep.
There's an understanding that whatever I would tell Jonathan, whatever he would tell me, was not done in a vacuum.
Yep.
It was okay because so much of when we get into the issues of privacy and everything else, there's not a clear switch flip that something's a problem.
Right.
So much of it relies on customer understanding, customer consent, but there are often terms like reasonable, like material, things like that. And that's where understanding, both from the counsel's perspective as to what the practical effect of something that I ask a question about comes into play in that determination of reasonable versus material.
Yeah.
And conversely, from the CISO side, when looking at, okay, here's what I see as the issue, and being able to take that and counsel saying, okay, yeah, here's where that fits into this. So really, this is what needs to be prioritized,
Right.
is this particular issue, and whatever controls that you are developing need to be structured and developed and implemented in such a way that people are aware of those particular risks and technical elements.
Right. With that, I hope we got your guys' interest on this. This stuff, I love this stuff, and I love working with Tom. And I think that just the beginnings of the conversations we had, because almost every single one of the things we covered today is a whole episode by itself. And I actually hope it turns into that.
I think you're right, Jonathan. And I think that, what I would say is watch this space there, because you're going to see something come out that's going to be branded somewhat differently. And that we expect that the podcast may get your interest. But the other thing that both of us have found when we present and teach on this subject is what matters most to the audience in many instances is the takeaway.
Yep.
So one of the things that you will see as we put these podcasts together is you'll have some information that you can take with you to, just as an example, to put a clause in your contracts that say any personal information I provide this vendor stays confidential, regardless if they've got it already.
Yep.
Or here is a policy that I want to put in front of my employees so they understand the importance of this. Even that just because they have the information doesn't mean they can do whatever they want with it.
Right.
And a lot of this may sound to some of you out there pretty basic, but unfortunately, we found time and again. Even if it may be basic to some people, for others, it is a brand new day.
Oh yeah.
And that's why we're here to help those of you in that position face that brand new day. And for those of you that are already there, hopefully you will learn either some wrinkle or some new way to look at things from the discussions that we have. And again, we look forward to being able to speak to you all in the future. And if you have any thoughts as to specific topics you'd like us to cover, please go ahead and let us know.
Yep.
We're putting the schedule together now. As Jonathan said, we've got some ideas, but again, the idea for this is to help those of you out there who either are not in a position where you need to be or feel like you could be in a better position to get you there.
Right. I love it. This is why we do this podcast. This is why I do the things for this podcast, is to help people think differently about these topics and to help CISOs grow. And I hope on your side, it's the same thing on the lawyers. So you're talking about the technology side and the security controls.
Well, that's why I teach.
Yeah, absolutely. So, all right. With that, again, Tom, thanks for coming out. Thanks for jumping on the podcast with us.
All right, Jonathan, thank you for having me.
Yep. Everyone else, I hope you have a wonderful rest of the week. We've got some great shows planned in the future, so check back with us. We have a variety of podcasts here at Alias. We have the Secure AF podcast, which is this one. We have our After Dark podcast. We have our SOC Brief, which is a great new podcast we're doing where we're giving people a 10-minute snippet of information every week that they can go back to their organization and hopefully protect their organization. And then this new podcast, we haven't came up with a name yet, but we're working on that, but it's going to be something fun. So everyone, thank you so much. Thanks for joining us. We'll see you next time.
Thanks, everybody.
The Secure AF Podcast is a production of Alias Cybersecurity. Visit us online at aliascybersecurity.com. All rights reserved.